Good morning, everyone, and welcome to this technical conference to discuss the implementation of Public Service Law, Section 66T, that addresses the oversight requirements for energy brokers and energy consultants. I thank everyone for making the time today for this conference. Just going to go over a couple housekeeping matters to start. If we can go on to the next slide. So starting off, for folks on the phone, we have nearly 300 participants on the phone. All attendees are muted upon entry. We ask that folks use the raise hand function to speak. Raise hand is located at the in the bottom right-hand side of the window. Once we see questions, we'll call on those to make a comment or ask a question, and then we ask that you lower your hand after the fact. Please do not use the chat function. No one is going to be monitoring that regularly here. We want to have all questions and comments made verbally so that we can have a discussion. And the Q&A is only for technical issues. For those in the room, we have about 15, 20 participants here in Albany and a few in our satellite locations as well. For the satellite location, we have New York City and Buffalo. We ask if there are any comments there. I know Buffalo is actually an empty room right now, so we'll probably just be focusing on New York City. Same process. The city has joined the webinar, can raise their hand. We can ask questions there down in the city and address anything that we can. For those in the room here in Albany, we ask that folks be polite, try to identify yourself to speak, because everyone just yelling and talking over each other. We also ask that you use a microphone. We have these little spiders that will pick up the audio. It'll pick everything you're saying up much better if you use a microphone. For folks sitting in the back, if you want to ask a question, just ask to please come up and grab maybe the microphone right here at this open seat. And for all participants, in person and on the phone, we ask that you identify yourself when speaking. We're not going to go around and do introductions or appearances in the interest of time. So whenever you're speaking, we just ask. Okay, sorry, IT issues going on. Someone's having some audio problems, but I think it's limited to just one individual. Identify yourself when you speak, just so that folks know who you are and who you represent. See. Oh, also this meeting is recorded as I mentioned, and the slide deck in the recording will be posted after this meeting. And I think that, one last thing, sign-in sheet. Folks here in person, please remember to sign in on the sign-in sheet. And with that, can we go to the next slide? Just have a brief agenda here. We're going to start off with some background on the legislation and the commission's order. And then really the bulk of this meeting is to discuss questions. We asked that a lot of folks that everyone submit questions in advance, and we received a bunch. We're going to start by going over the ones we received in advance, which probably cover a lot of the common themes that we saw and that folks maybe have here today. But we do want to kind of keep an open discussion, so it's not just us reading off of a list. If there's follow-up questions or additional things, let's try to air them out here. If we have time after going through all that, we'll just kind of turn it up to kind of an open discussion. But I imagine going through the questions, we'll have plenty of discussion to fill the 2 hours we have here today. That was all I had for the agenda. I think I'll turn it over to Richard Berkeley for some opening remarks.
Thanks, Tom, and thanks everybody in Albany and New York City, and hopefully in Buffalo, and everyone online. We greatly appreciate your showing up. Even more than that, and I think you are all folks who have done this before, we appreciate the thoughtful questions that you gave to us in advance so that we would have something to start the discussions on the various topics that the industry or industries have shown concern on. I remind you all that thoughtful and engaged questions are an important part of proceedings like this. That's how the government gets rulemakings right. It's how we get regulation right. And I think getting regulation right in this instance is very important, not just because the legislature placed a new requirement upon the Department of Public Service and also upon the industries that are represented on the call today and that we'll hear more from in the future. But because the legislature's goal was protection, and not just protection of their constituents, but remember that you are also the legislature's constituents too, and they're trying to protect you from bad actors who may not be willing or able to comply with the regulations that are in front of us all. And this will help keep them out and allow you to compete in a field where everybody is playing by the same rules and playing honestly and transparently. So I thank the legislature. I obviously thank the executive for thinking this was a good idea and going forward with it, just as I thank you all for being here. I think this will be the first of many discussions because we at the department are learning about this area, and we will continue to learn, and you'll continue to help us learn over this year. So in advance, I think occasionally answers are not going to be as fast as you want, but you will get answers. That's part of the thing that the department is very good at. I point to all the highly accomplished staff on both sides of me and behind me. Those are the folks that you will be talking to over the next year. And it will probably be less of us after the first year, but in the beginning, where there are hundreds of companies registering at the same time, there'll be a lot of people thrown on this, and then it will eventually end up, if any of you play in the ESCO markets, the DER markets, you'll know that it narrows down usually to 2 or 3 people, but that's in the future. So in any case, that's all I wanted to say. Again, thank you for all showing up and showing up online. I'm looking forward to a good conversation today and good takeaways. And I will point out, by the way, and you'll hear this from time to time during our answers, as I think many of you, if not most of you know, there are several petitions that are pending in front of the commission. And so you may occasionally get an answer that says that's addressed in a matter before the commission. We will not answer those at this time. Staff does not speak for the commission, and the commission will act in due time when it does. So thank you all. Thanks, Tom.
And with that, I think we can jump right into the agenda. Again, as I mentioned, we're going to start with just some quick background on the legislation and the commission action. With that, I'll turn it over to our colleague, Kelly O'Donovan.
Hi, everyone. I'm Kelly O'Donovan. I'm going to give you a quick rundown of Public Service Law Section 66T, which was signed into law at the end of last year. It prohibits an entity from acting or identifying itself as an energy broker or consultant without first registering with the commission, and prohibits any person from accepting a commission, service fee, brokerage, or other valuable consideration for selling, soliciting, or negotiating an energy contract in New York if they are supposed to be registered and are not. It also authorizes the commission to describe the manner in which energy brokers and consultants operate, and empowers the commission to deny or revoke registrations. As part of the registration process, brokers or consultants have to demonstrate financial accountability and pay a $500 annual registration fee. Energy brokers and consultants are also required to disclose a form and amount of compensation that they receive. And the law also prohibits giving rebates to ratepayers or anyone that represents the ratepayer, and establishes penalties for violations.
Good morning, this is Adam Palmatier. I'm going to go through the next couple slides. This slide goes through some high-level bullet points of the order, and it was adopted with modifications, the staff proposal to implement the requirements of PSL Section 66T. It required energy brokers and consultants registration by August 31st of 2023. It adopted modifications to the UBP and UBP DERs, including sections in both applicable to energy brokers and consultants. It directed staff to file additional modifications to the UBP and UBP DERs generally, and it also directed us to convene this technical conference. And on the next slide, we put together some of the most helpful and important links, specifically regarding registration. The first link contains a DMM link directly to case 23M0106, which contains the order and associated documents, It also has additional information, including definitions, a template for the letter of credit, the registration form, links to the UBP and UBP DERS, and instructions for sending in the letter of credit and $500 annual fee. The second link is the DMM matter number for filing registrations. The third link is leads you to a 9-page document that provides step-by-step instructions for creating an account and becoming an e-filer. And the fourth link is a 5-page document with step-by-step instruction for filing in DMM.
That's a question. Is this presentation, sorry, I'm in a transition from couch, right? But do we have this presentation? Is it on?
This has not been posted
Oh,
anywhere,
okay.
but it will be afterward.
Perfect, thanks.
Yep, and with that, I'll turn it back to Tom and Kelly to start going through the questions.
Thanks, Adam. And before we get into the questions, I did just want to give like kind of a simple disclaimer. Richard hit some of it already, but just want to reiterate that, you know, the commission's orders speak for themselves and staff can't speak for the commission. You know, we're here to help and provide guidance based on our understanding of the commission's order, but we can't change the order. Anything we say here today is just staff, you know, trying to work with you guys to help understand and help your implementation of these requirements, but only the commission can actually change the order. And as Richard mentioned, there are several petitions for rehearing that were filed. You know, and we did receive some questions on those topics. For the most part, I think we're going to let the commission speak to that. We're going to have a direct, you know, response from the commission on those issues. So, you know, to the extent we can be helpful here today as folks are preparing registration documents and like that, we will. But certain issues are you know, yet will be decided again at a future date. And then I also just want to note the extension requests. In addition to the petitions for hearing, there were several extension requests of the August 31st deadline. Those have been received and are currently pending before our secretary's office. The secretary has the authority to grant those extensions, and I expect her to issue a ruling one way or another in the not too distant future. I was hoping we might get it before today, but no such luck. And with that, I think we can jump right over to the questions. Kelly, you want to get us started?
Sure, so we have a whole list of questions that we received. We're just gonna go through them and provide answers. So to start off, to what extent, if any, do the broker and consultant requirements apply to those working with or for demand response providers? So these definitions focus on the furnishing of a gas or electric supply agreement. If you're working solely with a demand response provider, that would not make you an entity subject to registration for a broker, as a broker or consultant for the purpose of these rules. And next, a lot of people have asked about the demonstration of financial accountability. The commission did say in its order that it will only be accepting irrevocable standby letters of credit and explain the reasons for that. They're generally easier for us to collect on and more secure way of demonstrating financial accountability. A lot of questions related to the difference between an energy broker and an energy consultant.
Let me actually give that example. Yeah.
Sure.
Yeah, we did get a lot of questions about this distinction. And, you know, I think some of the most important language from the definitions that jumps out at me to distinguish between a broker and consultant is the concept of taking on the legal and contractual responsibility for the, you know, the customer enrolling in the supply agreement. So, you know, I think of maybe just a real basic example that we've seen in sort of the ESCO realm is, you know, there may be these brokers out there that are actually, for all intents and purposes, signing up customers. They're executing agreements saying, I'm going to, you know, this customer is agreeing to enroll in a supply product. I'm going to get a bunch of customers, and then I'm going to go in turn find an ESCO to serve them. That entity would be more of the broker. They're taking on a legal responsibility to enroll that customer in a product. I think the opposite side of that, potentially like a consultant, would be more along the lines of the person that's connecting the dots. So they're not executing agreements, they're not signing the customer up, but they're marketing to the customer, saying that, hey, we suggest you go with this guy, or providing information on competitors in the area. I think that looks more like the consultant side of things. And again, I think the main distinction is really that assuming the legal / contractual responsibility that separates the brokers and consultants.
Tom, we have a hand up in the chat.
Yeah, let's go to the question on the phone.
It would be Andy Mitri. Unmuted.
Go ahead, Andy.
The financial requirements, was there any consideration given to cash? I understand wanting a letter of credit because it's easy to draw, but there's nothing easier than cash. Is there any consideration given to being able to provide cash instead of a letter of credit?
Personally, I hadn't considered cash. I know there are limitations onto what the commission can accept and what they can hold. There may be an issue with the department actually taking cash. We can go back and talk internally on that, but ultimately, as it stands out, the order did require the standby letter of credit and did not permit cash.
Okay, yeah, I understand that. If you could take that back and see if that would be an option, that'd be great, just because letters of credit are just sometimes difficult to obtain, and the letter of credit format you have, certain banks may or may not want to write. So that's just to have a single method versus just having at least dual, where someone has the cash and they want to be able to provide that security. This is just another option. So I appreciate the consideration. Thank you.
Yep, understood.
You
And
have a couple other hands on the line.
absolutely. Let's go to, take it away. Edmund is first there, it looks like. Edmund?
Consultant. Yeah, can everyone hear me?
Yep, we can hear you.
Yeah, can you provide some additional clarification in regards to the difference between the broker versus consultant? Based on the definition that you've provided, there are several brokers that request authorization from the customer in order to execute, right? At no point are those brokers taking legal, they're taking the legal ramification of the supply, right? So would those brokers not really technically be consultant based on the definition that you're providing?
So yeah, if you're saying that they're not taking on that legal contractual responsibility, then I think that would take them out of that broker definition. And one thing I should say maybe at the onset, a lot of folks obviously are thinking about their business model and how these rules apply to that business model. But as we're all aware, there's a whole slew of business models out there that approach providing energy services to customers very differently and have different contractual relationships amongst like the providers and the brokers and consultants. So the rules are crafted as to try to be as generally applicable as possible. And to the extent we can here today, we will try to narrow it down and provide guidance on specific examples, but we're trying not to get into too specific of hypotheticals and get down a rabbit hole that it really only applies to one or two entities. But with that, Primer, did that answer your question, Edmund?
Yeah, I guess to some extent. I'm just thinking about several brokers that work with management companies, where the management companies are still executing the contracts, but brokers are not taking any contractual obligation when it comes to the supply contracts. So
interesting. Maybe I misunderstood. You said that if they're executing the contracts and also not taking on any contractual responsibility, maybe it's a one-off we can handle outside of this. Maybe leave it at that.
I might be able to add some clarity.
Yeah.
Go ahead. I think I know what he's saying. Hi, it's Dave Pickens from Spread. There's a lot of brokers that will go out and, they go out and they find customers and they say, we'll get, we'll shop this for you. So that they'll go out and they'll get like 3 or 4 prices from various suppliers. Then they go back to the customer and they show them that and they let the customer pick which one they want. Or they say, this one's the best price, this one has the best contract. In that case, I guess what I'm hearing you say, that person wouldn't be a broker, but they'd be more of a consultant. Because the actual contract, the execution would be between the supplier and the customer with a fee for the consultant, I guess.
Yeah, that's consistent with my understanding.
I think that'll maybe resonate out in the field a little more.
Appreciate that clarity.
No problem.
Yeah, Richard.
And before we go into too many highly specific hypotheticals that I'm sure many people on the phone would like to give us one by one, I think we all understand that there are a large variety of different business models that exist out in the field right now. And therefore, this is going to be, as Tom said, we have these high-level definitions, there are going to be some factual determinations on a case-by-case basis, but not today. That'll come as we go through the application and registration process. So thanks, and thank you for chipping in.
You're welcome.
All right, I think we'll get a couple more on the phone here. I can't see what order they're going in, so I'm just going to go down the list. Let's go with Ed next. There you go, Ed. Oh, he's muted. Hold on. I got it. Oh, okay, he lowered his hand. Let's go with Chris. Chris on the phone? Also lowered his hand. We must be answering these pretty quickly. Let's go with Angelo.
Hello?
Hello.
Yeah, this is Angelo from ClearPoint Energy. My question is, you clarified demand response, providing those services is not part of registration. What about the term in the industry is subscription recruitment for community solar remote crediting projects? Does that require registration if you're providing subscription recruitment services for solar farms?
So I think the same answer applies to that one. It's not a commodity service, CDG. Really what you're providing in those subscriptions is bill credits. And generally speaking, we haven't considered that to be a pure commodity service. So for the same reason that those demand response those facilitating demand response products wouldn't need to register. Those that are just facilitating a CDG product would also not have to.
Okay. Are you, a different question, are you taking questions on the form of letter of credit, or is that too technical?
Well, we are taking questions on that, although I do think we have a few more on the letter of credit a bit farther down in the list. I know we tried to have some organization here with these large number of questions. If we could come back to the letter of credit questions in a little bit, I'd like to try to address some of these kind of applicability ones first.
Okay.
Okay, looking back down at the list here, and it's changing constantly. Let's go with Shannon. Go ahead, Shannon.
I am the executive director of the Energy Professionals Association. I was hoping you might be able to provide us some guidance on whether or not our members should register as a broker versus a consultant, if they may operate as both.
Yes. That was something that I think was, it was specifically laid out in the proposal, and the commission order adopted the proposal, but didn't specifically talk to this point because we didn't receive any comments on it. But for clarity for everyone, because I think we did get this question elsewhere, if you're both, you register as a broker, essentially. The registration form and everything is essentially the same. You'll just check a couple of boxes. And the real distinction comes in the letter of credit and the amounts. So it goes with the larger amount. You don't need to add them together and do like 150, just do the one for 100 for a broker.
Okay. And then to take that just a step further, let's say that I only operate as a consultant as of today, but you know, in the next 6 months, I may get hired on and work under your definition of a broker. Do I just make an amendment to my application and have to increase my letter of credit, or what are the next steps there?
Yep, that's exactly right. The new terms of the UBP require updates, you know, when there's changes to the original registration package, obviously that would be a change. And it's just as you said, it would be just updating it, same filing in the same matter number. And if necessary, like it would be in this case, filing a new letter of credit and everything.
Great, thank you.
Sure. Moving right along here, let's go to Francesca on the phone.
Hello?
Hello.
Yes. My name is Pedro Gonzalez, and I wrote a letter yesterday dated August 7th. I articulated the letter to the commissioner. And in that letter, I had raised a couple of issues regarding how legitimate this whole situation is, because 66-T violates the due process clause in a way, but it does say that you're required to provide a bond or some other form of instrument. Now, the situation is that I spoke to one of your guys there. I think he's the assistant counsel, Thomas Dwyer, assistant counsel, Department of Public Service.
Yep, that's me.
Oh, that's you. Okay, I can't see you. Okay, now you agree with me that, and you said, and I quote, you are correct that the legislation did not detail the exact form of financial accountability to be utilized by energy broker or energy consultant. Is that correct?
That's correct. The law didn't. The commission order is what detailed that.
Okay, so here's my problem. My problem is that because just like the young lady, I don't know her name, but she said it's easy to collect on. I don't know if the consultant realized that once you put your money there, you don't get due process, that your money can be pulled out at any given time. Whereas a surety bond allows you to be able to get into a discussion or dispute between the three parties involved. Okay, so if the only reason you're doing it is because it's easy to collect, that is wrong, because due process needs to take place. If I'm putting out X amount of dollars and in the midst of the year, someone disputes and says someone commits fraud or something against me, I have no way of defending myself. Is that correct?
No, I don't think that's correct. And maybe we could take a step back on the process point,
Yes.
because this is a question that we received in the broader solicitation for questions as to how the commission would go about drawing upon a letter of credit. And anyone who's participated in our retail access market is probably familiar with like the UBPs and the process that goes through for enforcement. And those same processes were adopted for energy brokers and energy consultants. So it's not the case that the commission's just going to see a violation and go and draw on the letter of credit immediately.
Okay,
There's
so
always
one thing-
process involved. If there was an issue, it's usually brought to staff's attention through consumer complaints. And when we have complaints at a significant level or that are just concerning by themselves, we'll oftentimes reach out to the company to see what's going on. If it's a real concern, the initial kind of step is a letter from staff identifying apparent violations of our rules and asking for a response from the company. If the company doesn't respond, or if the response indicates, yeah, they have violated our rules and aren't going to cure it or cannot cure it, then it goes to a more formal process where the commission will start out with an order to show cause that lays out the alleged violations and again provides the company with an opportunity to respond. After that, then the commission will issue kind of a final order, either imposing consequences or what have you, and it would be as part of that order that the commission would or could potentially direct the letter of credit to be drawn down on.
Yeah, but it's.
But that
it's
won't always
required,
be the
it's required,
case.
But it's much easier for them to immediately collect on that than it would be in a surety bond. And another factor is that for me, as a small minority business, I'm able to get probably a surety bond much cheaper and much faster than I could a letter of credit. I mean, what that means is that it'll tie my whatever money I have would tie it up. $50,000 may not be a lot for some people, but $50,000 is a lot for me. It really would tie up all, practically all the cash that I do have. Okay. Now here's another thing too. The governor signed the legislation. The legislation says bond. It doesn't say any other instrument like a standby letter of credit. So let me put it this way. The commissioner cannot make an order that is not in guidelines with the law itself. And you know that as well as I do. So I have a problem with that. And I think that what you should do, the letter I sent you yesterday, which you acknowledged by email, I think that all the brokers should have a copy of that letter. So they should be informed about what I wrote. They may have a problem with that, and they may not. They may refer this to their attorney so they could take a real good look at what's going on. So I think that, don't you agree that everybody should have a copy of this letter?
I believe you said you filed it correctly?
No.
Correct?
I just filed it. I sent it out by certified mail, and I send it out to all the commission. And what I'm asking you is that I want that letter to be made available to all the broker dealers, all the brokers consultants, so they could read my letter and they could be well informed as to exactly what you guys are doing. What you guys are doing is not legally correct. And I just want to point
We'll
out
agree to
before I
disagree
leave
on
this
that one.
conversation, I do want to point out that a couple of the headings of the article that I wrote. One of them is
Mr. Gonzalez? Mr. Gonzalez, this is Richard Berkeley. I'm the Director of the Office of Consumer Services. I just wanted to break in here for a moment. You have a set of concerns that are specific to you, which may or may not be, I should say, may and may not have already been thought about by your colleagues in the business and their counsel. I assume that everyone has spoken to counsel at least once before this point in the process. But if you wanted to place your letter into DMM, that is into the public space in this proceeding, you're more than welcome to do that. I would suggest that you may wish to redact some things that are perhaps personal information, because we generally do not want to have personally identifiable information and things that go into the public record of this proceeding permanently. So that letter will be there forever with people able to look at anything that's in there. If you don't have a concern with that and you've already put it in, that's fine. Let me back up a little bit though, which is the purpose of the technical conference is not for one person to discuss their concerns at great length, but rather for the entire industry to go through the 8 or 9 different categories of concerns that we're hoping to be able to answer to today. I think we've heard your concerns. Mr. Dwyer's already spoken with you, and I'm sure he has no difficulty with continuing to speak with you. But I think you've made your point and we can move on at this point.
Okay, and let me move on by just saying the following. I am going to move on by turning off this conference. But before I do that, I want to mention something that is extremely important. I have articulated this letter very well, I believe. And I also believe that all the concerns that you guys are going to have today is addressed already in that letter. So I want you guys to have a nice meeting, and I will post this up, and I hope that all the brokers and all the consultants will look at the letter because it's well articulated, and it does address some of the legal issues having to do with the due process, the 14th Amendment. So please. Anyway, thank you for your time.
Thank you in advance, Mr. Gonzalez, for posting the letter.
Yeah, I'll actually note that the letter is already posted. It was posted as of this morning under the public comments under this docket, the 23M0106.
Okay, well, thank you very much. I really appreciate it. And I hope that everybody reads the letter and get involved in what's going on here. But I want to remind you that the commissioner does not have any power to rewrite this law, period. It is the law, and and if you're going to make an order, it has to be in guidelines with the law. Gentlemen,
Thank you, Mr. Gonzalez. Let's keep going here. Andy has been patiently waiting this whole time. Andy Kern, please go ahead.
Very much. In the definition that you provided for broker earlier is in other states categorized as an aggregator, and broker in those states would be any entity that takes possession of the contract in between signing. So if I request a contract from a supplier, they send me a blank contract with the rates filled in and all the information filled in, and then I go and request the client to sign that. Client signs it, I take it back again in possession, and then I send that to the supplier and request a countersigned copy. That's a broker. A consultant in other states generally works for one supplier or only or never really takes possession of the contract. Does it some electronic way directly with the supplier's platform. And an aggregator is your definition of I have clients that I have power of attorney and I group them together and I sign for them as a as their aggregator. And I put them into one big contract. And that's what the other person earlier mentioned for property management companies. They do the same thing as part of their property management duties, which is sign contracts on behalf of the owners. But they don't do any of the soliciting. They still use a broker to go through and negotiate that contract. So I just want your ruling on this and understanding on this.
Yeah, so I mean, as we understand that there's different definitions adopted, in the New York law than maybe adopted for these terms in other states, or just in the typical way they're thought of. I've had people say that, well, that's not what I think of as a broker. And I understand that, these words may have multiple meanings in different areas, but ultimately, for the purposes of applying these requirements in the registration processes, we're focused on the definitions here in New York. And if a broker is, as we've defined it here, is actually what you call an aggregator or something, well, that's all well and fine, as long as a broker here in New York, you're registering and following the rules as applicable.
So do the property management companies that sign for the other legal entities, do they need to register as something?
Potentially, yes. I mean, again, it's tough going down for each individual business model here, but if you just go back to
this is a very large percentage of the New York City clients.
Okay.
And New York State as well, but that's a very large percentage of the accounts in all those major buildings throughout the city and any of the populated areas.
Got it. So again, for this business model, if they are actually, taking on that legal and contractual responsibility, which from the hypothetical, it sounds like that they would be, of these supply agreements, then they very well may have to register as a broker.
Okay, when could we get an absolute on that? So that we can inform all those property managers that that's what they would need to do.
Well, again, the absolute is the commission's order. It's ultimately up to the property managers and anyone else here to determine whether or not, they are a broker or a consultant. We can provide what guidance we can to help with that, but that unless the commission is going to speak to it again, like potentially on its order for rehearing, there isn't anything more formal that staff was going to put out on this.
Right, and Tom, I can jump in here. Alicia Sullivan, I'm Consumer Advocacy Council. Just as a reminder, of course, the ESCO, the providers here, the entity that has the legal responsibility for registering, they individually have to determine the legal responsibility and whether they fit as broker or consultant, right? We're here to give guidance. We're certainly not here to give legal advice to these entities. And my advice always as counsel is ask your attorney. So some of the, we can help you with the guidance, but at the end of the day, each entity that is required to follow the law has to determine factually, does this individual in your organization fall within the bucket of broker or consultant? We again, will help you with the technical parts of it, but I don't think we can give you an absolute answer, and I don't see the commission giving an answer in the future on something that really is a legal responsibility of each entity.
And I understand, I'm just trying to, we consider brokers and consultants consider those management companies as clients, but because they're taking that lead, that power of attorney portion of it and the legal responsibility for the contract for the owners, that puts them square in the middle. And I just, I'll reread the order to understand the repercussions of them not registering.
And before we go on to more questions, I just want to know, because I see some just alerts popping up here. As a reminder, we're not monitoring the chat function. I guess folks are free to use it, but we're not monitoring it to answer questions. If you do have a question, please raise your hand and ask it. And for the Q&A, please leave that for technical issues. We've already had a couple that we've been able to quickly resolve through the Q&A, so let's leave that clear.
And Tom, before we take any more questions, are there any of the questions that were previously submitted on broker versus consultant that you and Kelly want to point out? Because we probably only have about 15 minutes for each category if we're going to treat all 9 equally. And we've already gone way past that 15 for this first question, which is obviously an important question. But if there were any of those questions we got in writing in advance that you might want to point to as being valuable for everyone on the phone in the rooms to hear, I'd suggest you do that, and then we potentially close this topic and move on to disclosure of compensation, since I'm sure there are some people that are interested in that topic too.
Yeah, I think for the most part, we're actually answering the pre-filed questions as part of this discussion. We've already checked a bunch off here, I see. And this was probably one of the larger percentages of topics, was this one. So, I can scroll through here and see if there are any extras, but let's in keeping with this discussion on kind of the applicability and the broker consultant, the get more alerts popping up here. Distinction. Let's go. Let's see. I think James has been raising his hand for quite some time. Let's go ahead, James. You're unmuted, James.
Hello?
Yep, we can hear you. Hello?
Property management company who is representing the ratepayer also register as a broker or a consultant? That's the full question. They're representing the ratepayer. Co-op and condo management companies, even though they can sign contracts, they do not get sued, or they can be sued in some cases. In an instance where a building, an entity that they're representing were to pull out of a contract, the ESCO is going to go after the entity, and then secondly, speak with the management company. But can a company who is representing the final ratepayer register as a consultant or a broker? That's, I think, the question that most people are asking in the city. And then my other question, just to keep the meeting moving, do you have a phone number when we have these offline follow-up conversations? Is there a phone number and a contact name for someone that we can follow up with after the meeting?
Yes, answering the first question first, again, based on the fact pattern that you presented, it sounds like, again, this person who's representing the customer is still undertaking the legal and contractual responsibility for the ultimate supply agreement. So the answer is yes, someone who representing the customer can register, and in some cases, it's going to be appropriate for them to register. And then to your second question, yes, on the website, the broker and consultant webpage that we set up, and there's a link in this slide deck, which will be shared afterward. There's contact information for my colleague Adam Palmatier, who's been kind of intaking a lot of these questions, and then we as a staff team have been trying to make sure we get responses out to folks.
Okay, so a management company can register as a broker or consultant.
We won't prohibit it.
Okay. Thank you.
Sure. And then let's see. Chris, you there we go. You have your hand raised. Go ahead. You're unmuted, Chris. All right, let's move on to making this refreshing here. Tom Devlin, unmute.
Very much. Can you hear me?
Yep, we can hear you.
Great. I appreciate you guys hosting this conference. You can see from the number of attendees that there's a lot of people interested in this. I don't want to belabor this point, but I did want to bring up something Mr. Gonzalez brought up. My company's in a fortunate position, I think, but basically, my question is, have any of the PSC members actually been through the letter of credit process that you're asking us to go through?
When you say PSC members, you mean the commissioners?
Sorry, the commission. My bad. Yeah.
I don't believe the commissioners have tried to get a letter of credit for an energy consultant.
I'd like to walk you very quickly through it, right? A broker registration, which we require a $100,000 letter of credit. This means that a broker would have to put $100,000 of cash into a bank account that may or may not accrue interest. Then the financial institution will charge setup fees that can be up to $1,500 that may be renewable annually. Lastly, that financial institution that is taking your money and putting it in a non-interest bearing account will turn around and charge you 2+% interest a year to issue that letter of credit. So what that means is, very quickly, the opportunity cost of putting $100,000 in a non-interest bearing account is at minimum 5% right now, right? So $5,000 a year plus 2%, that's another $2,000, it's $7,000 plus registration fees to issue the letter of credit, which is up to $1,500 plus the $500 broker fee that you're asking. So my point here is that the smaller consultant or broker is being asked to put up a significant amount of cash. And I think what this ruling will cause is much more consolidation in the industry, leaving much fewer options and choices for the customer. Additionally, $100,000 that a small broker, they might hire someone to help comply with these orders, and now they won't be able to do that because they've got $100,000 sitting in a non-interest bearing account. So that's all I wanted to say. I just wanted to make sure you all understood how this order is impacting the smaller consultant and or brokers, and the what I think will be the long-term effect of this order, a very quick effect. Thank you.
Thank you for those comments. Going back to our list, again, I think we are hitting most of the ones that we got in advance, but here is one that's a little more specific that we haven't gone over. Will entities that are CCA administrators but also function as consultants, brokers outside of CCAs be required to apply for a separate, and they use the word license here, which isn't the right word, but I understand what they mean. And this is a really good question because this is even outside of CCA. The answer is yes. So if they're active, the commission's order for CCA, for example, said that administrators themselves technically probably would fall under these definitions, but for the reasons explained in the order, mainly that we already have a much more thorough and in-depth process to review and approve new administrators, that they're not going to have to follow this registration process. They can continue to utilize the more in-depth process that we've set up. But if a CCA administrator outside of those normal CCA activities was also acting as a consultant or a broker, that would necessitate registration. And I think the same can apply to any number of DER suppliers or even ESCOs. I mean, that was another point made in the order, that ESCOs themselves do not have to register automatically. The definitions specifically exempt ESCOs with the language that says, but does not take title to the energy sold, which ESCOs do. But separate and aside from their ESCO services, these companies may also be acting as consultants or brokers, and that may necessitate registration. All right, I think we're getting near the end of these questions. Let's see, still a few more hands raised, and I do want to confirm the hands raised are those dealing with kind of this applicability. And if you could just hold off on some other ones, we'll be moving off this topic shortly. But let's go to Tony. I think he's been waiting for a little while here.
Hi, can you hear me?
Yep.
Thank you. Just have a quick question. Before I say that though, I do want to support what Mr. Devlin just went through. I think he's right on with his comments. My question is, if you're working as a consultant on behalf of a customer and for procurement, you're simply paid a retainer fee by the customer, there's no fees from the supplier being paid, is a registration required?
I'm sorry, can you say that one more time?
The entity is working as a consultant on behalf of a customer, that they're paid by the customer a retainer fee for those services and maybe others. Is there a requirement to register as a consultant?
I mean, there may be, based off of that limited fact pattern. I can't say one way or the other, but if they're acting, in a way as described in those definitions, like, the whole term about what I generally think of as facilitating the sale of a commodity product, then they may have to register. Again, these are more activity-based, these definitions, not entity-based. So just because you're one type of entity or because you're working for one type of entity doesn't necessarily mean these are applicable or not applicable. It's really based on the individual activities of the entity.
So you wouldn't be facilitating the sale, you'd be facilitating the purchase.
Maybe we're splitting hairs here, but I think that would still probably put them under the definition of at very least a consultant.
Okay, I mean, my understanding is a lot of the purpose of this ruling is to protect customers and to provide transparency on fees, which in the scenario I'm describing, the customer is clearly aware of the fee. They're paying the entity directly. So there's the transparency is there, and there's the entity, the consultant is not taking title, it's not signing, it's simply working with the party on their energy supply and energy portfolio and maybe other things. And they may charge them a retainer quarterly or biannually or whatever. So it seems like it's a stretch, but that's fine. You've answered it to a degree. My other question is simply, if you're doing natural gas and electricity, you have to submit two registrations and two letters of credit, and is that correct, or?
No, no, certainly not. One per entity. There is a fields on the form to identify, I think, the services you're providing. But yeah, one register per entity, not per commodity.
Okay. All right. Thank you.
All right. We have a lot of questions on this, but I do want to make sure we hit some of our other topics. I think maybe we'll get to some of these applicability ones too as we continue to go through those.
Tom, can I ask a question?
Yeah, in the room.
I'm just looking at the clock and
Amanda.
Amanda Trinity from Country. And we only have an hour left and you haven't even left the first bullet. If we don't get through all of the pre-sent questions, will you publish like answers, or how will we address that?
Chances are, we've sort of talked about this a little bit internally and haven't made a game plan, but I think chances are there'll probably be another meeting like this set up. We've also kicked around the idea of creating kind of like a FAQ type of document. We haven't created that yet, but we'll take that back after this meeting, and it might depend on how
Trying
far
to
we
manage
go.
my expectations.
Yeah.
And not ask any questions.
So I want to shift gears just a little bit to the disclosure of compensation. And I think, for the most part, a lot of these questions fall into one or two very common themes here. But very generally, we got questions regarding who is responsible to disclose the compensation, the broker/consultant or the supplier. And this is one that the commission did specifically address this, but this kind of going back to what I said before, broad rules that apply to multiple different business models. And I think in most cases, it's going to be ultimately the supplier that discloses that compensation as part of the customer sales agreement, as the disclosure statement and everything right up front. Now, the commission did say, though, when there's a direct contractual relationship between the broker and the consultant, that it should be disclosed by the broker directly. Understand, though, based off of a lot of discussion here with the industry, based off the comments and things, that there's not always that contractual relationship between the consultant/broker and the customer. And we got a lot of questions about, well, what if I don't have sales agreements? Or what if I don't issue transfer notices? The ESCO does that. The UBP kind of included all the entities, the broker, consultant, and the ESCO in these directives to account for the fact that it may be any one of them providing it. But ultimately, I think the fallback is if you have a direct contractual relationship with the customer, you should be disclosing your compensation. But in most cases where that is not, there is no direct contractual relationship, that compensation disclosure is effectuated on the sales agreement between the ESCO and the customer, and that's specifically right in that customer disclosure statement, which a lot of the retail access folks will be familiar with. So let's try to turn to some questions on that point. I'm not seeing any in the room here, so I want to jump to folks on the phone as hands shuffle around and change here. Let's go to Matt Shaw.
Hello, can you hear me?
Yes.
Hi, Matt Shaw, Sandwich Energy. I'm going to do my best to kind of give a little voice to some of the people who are in the chat. Can you help us understand how fee disclosure works for ESCOs that are paying landlords for their procurement business? It's a common situation, but essentially the supplier is acting like a consultant and the landlord or property management is acting like a broker, but they're also executing the agreement on behalf of the actual ratepayer who never sees any fee disclosure?
Well, it sounds like in that case, then that landlord is an energy broker, and they're going to be required to disclose their fee.
So that would be really the big question, because they're the broker, but they're signing the agreement even though they are not the entity paying the invoice. So the supplier is kind of also a consultant, and the customer is also kind of a broker because they're the ones executing the contract. You just mentioned the fee disclosure would go in the supply agreement, but the customer that's paying the invoices doesn't see that agreement, so they wouldn't see the fee disclosure.
I see the distinction you're making.
Sorry if I'm not articulating that well. It's
No.
That's a common circumstance that, I think a lot of the rulemaking that's happening here is intended to combat some of this activity in instances where customer may, an end user who's actually paying an invoice may be unaware of fees that may be going to somebody that had been added to that cost.
Understood. Yeah, that's an interesting question. We might have to take that back and give that a little bit of thought. I mean, you're right. The intent here is to make sure the customer gets the disclosure, and I think the general assumption is that the customer is the one ultimately executing the supply agreement to enroll. But in cases where it's the landlord, perhaps providing that disclosure on the supply agreement might not achieve that goal. I do know that there is another provision dealing with fee splitting that the commission addressed in the order that requires direct disclosure from the broker, even in cases where like a broader compensation disclosure is included on the customer agreement. So let's take that one back and think about that a little bit. As I take my note here, let's see. I know we have a few more questions on this. I think Tina has been waiting patiently for a while. Go ahead, Tina.
Hi, this is Tina, and I'm with an energy consultant, Consumer Energy Solutions, and I had some questions regarding the fee disclosure. Can you guys hear me okay?
Loud and clear.
Okay, great. So we are an energy consultant. We take no title to it. We don't contract with the customers directly, and we also don't charge a fee for our consulting services. All contracts are with the suppliers directly. There is a line here that says, in instances where the energy broker or consultant does not have a direct contractual relationship with the customer, that the energy consultant shall disclose to the customer on a separate written communication any fee splitting. Would that fall into, would I have to do a separate disclosure for that, or would it suffice to be on the supplier contract as we have no direct contracts with them?
Yeah, so and I can pull it up here in front of me, but that fee splitting discussion I think was a very specific issue was trying to address, not the general compensation disclosure. I think generally when you're talking about just in this case essentially ESCO disclosing additional compensation that is being paid for in the agreement that is paid to a consultant or broker. That is fine, done on the customer ESCO agreement, not a separate disclosure required by the broker. That fee splitting, though, I think was essentially a kind of a separate type of arrangement whereby the consultant or broker may have like a fee splitting arrangement. I think with a landlord might have been the example that was discussed, that isn't collected through like the supply bill. ESCO wouldn't necessarily even know about this this fee splitting arrangement. That was the instance in where the broker or consultant themselves had to directly communicate that to the customer, even if there wasn't some contractual relationship with that customer.
Okay. All right. Thank you for clarifying that. And I did have just one more simpler question. In the disclosure, it states that we should disclose how we are paid, basically. So we are paid basically by fractions on fractions of what they pay per kilowatt hour. So would we put that in dollar amounts or in fractions of dollar amounts? Because that is how we do it. We do it basically in mils of a dollar. We don't do whole dollar amounts. So would our disclosure match that, or would we do whole dollar amounts? Because we would actually have to calculate that, and it would change based on usage.
Right. I think there's a little bit of flexibility in what's presented there on the compensation disclosure. As the commission said that you need to disclose like the form and the amount and all that, but also understood based off of comments that maybe the specific amount isn't known at the time of contracting. And in those cases in particular, what entities should do is fill out the explanation as to how it's calculated. So if it's, maybe it's charged on per unit or something, or maybe it is a flat amount based off of enrollments. Be as descriptive as possible as to how it's calculated, so that ultimately this is messaging to the customer, so that the customer can understand where this additional fee comes from and where it's paid. With that, going back to your specific question as to how it's presented as fractions or mils of a dollar, I'm not sure, which is the easiest to understand for a customer, but I guess the guidance is just encouraged to be as clear and as descriptive as possible.
Okay. Okay, thank you for that. That did answer my question. I appreciate it.
Great. Let's go, got a few more on the phone here. Let's go to Mayor.
Hello?
Hello.
Yes. So just to elaborate one more minute, two people before.
If you could just identify yourself real quick, Mayor, sorry.
This is Mayor from NYSDPS Energy.
Thanks.
So just to elaborate another minute and then a follow-up question. So based on what two people raised there, which means that every management company or big building owner that has a bunch of tenants, let it be commercial tenants, in reality with this law would have to register. If not, they would be illegally signing agreements for the ratepayers. And I think that's an issue. There's probably 70 or 80% of landlords doing that. And I don't know even if there's a way out, because even, there would be a broker, but at the end of the day, the broker wouldn't talk to every individual tenant because their lease probably allows the building management or ownership to do that for them. And if that's the case, it becomes, a situation that some people are required to do a license, but some people throw a blind eye. I wish you could comment on that. And I have one follow-up question, which I'm not sure I see it in your categories, or maybe it's a subcategory, which is, compensation for the people that are working in the consulting or the brokerage firms that you pay them till now also commission as an agent or on a 1099. And I believe that is not going to be allowed. And I would like to see if you could elaborate a little bit on that, because that's also putting a lot of turmoil in the industry.
Yeah, so on the first question about certain people complying and certain people turning a blind eye, you may be right. There might be some of that in the state, particularly early on. The legislation did empower the commission to enforce these rules and go after folks that aren't complying. And we have a pretty robust enforcement group here at the agency now, and it's only getting larger. And staff will do their best to identify and go after folks that aren't complying.
But how are you going to change? Literally, the whole Manhattan, every office building works like that. I mean, they can't go and ask every tenant in the building, right? Do you agree with the price or the deal directly with a broker? Because it's one contract, but there's actually a bunch of ratepayers. So, I mean, it's not a matter of enforcement. It's a matter of how is it even doable? We have to.
Oh, I thought you had something else there. Understood, and I have that note here. I mean, I think we had a question about this. I think they specifically talked about sub-metering and it sounds like that's what you're describing here, that those types of arrangements. Let us take that back and get back to you on, how staff is looking to approach that.
Mhm.
And I apologize, can you repeat your second question?
The second question is, I believe a lot of consultants or brokers have people working for them, bringing in accounts that they pay till now commission. They could be called agents. They'll pay them 1099s a different way. And I believe right now it's not allowed. I believe there's a lot of brokerage firm out there that could have 5, 10, 15, 20, 30 people that like work under their wing. But the way I understand from reading the law, that will not be allowed. So how exactly, is your suggestion to go about it? Again, there's a second part which is going to go into your category 5, which is contracts entered into before 8/31. But I'm talking even going forward. What is even your suggestion? How exactly do you deal with that?
Right. So, and that is kind of another common theme that we got, dealing with third-party contractors. I've heard people refer like the 1099 contractors, dealing with agents and things like that. Maybe we can jump to that real quick, because again, we did get a lot of questions on that. The commission's order would require basically those separate independent third parties to register. So you may have mentioned like 1099 contractors and things. I wouldn't say that the law prohibits them from acting and providing these services, but that they would have to register in order to continue doing so. And then the compensation disclosure would be just as we've been describing. It would be disclosing that compensation paid to that contractor for their services. And, kind of taking a step back and broader on this, this is one of the issues that was raised as part of the, at least one of the petitions for rehearing. So again, I specifically said this is how the order reads and this is what it required. But as folks know, the commission can change things on rehearing. So there will be more to come, I think, on that. So probably won't go too much farther than what we've said already on that issue.
Okay.
All right, good stuff. Let's go to Layla.
Go.
Hello, can you hear me?
Yes.
Yes, hi, I'm sorry. This is Chris Schiller from Resolution Energy. And I apologize before, I'm the Chris you called on twice, but for some reason when you unmuted me, it would disconnect me. So I'm calling through my colleague's login. I have a couple.
No problem. Glad you were able to get on.
With regard to, and if I say something that's already been addressed, it's from when I was disconnected, so I apologize. But I did look at Mr. Gonzalez's letter, and I did look at the law, and I can tell you that I've had an attorney review it as well. And there is merit to what he is saying regarding the fact that the bond is necessary and not the irrevocable standby letter of credit. And it does seem that the Public Service Commission is changing what the governor's law actually was. That's just my opinion. We can agree to disagree, like you said. But I do want to just a couple general things on record, since this is a public hearing. I am shocked. I've been in this business nearly 20 years. I've served thousands of clients. I've never had a complaint. In fact, I didn't even market or advertise. Most of my clients came from word of mouth or referrals because of the job and the level of service a company had provided others. But this does not seem like an enforcement to get out the bad actors. This seems like an enforcement to crush small businesses. Seems like an enforcement to prevent new businesses from forming, and targets people that are of lesser financial means. Some of the biggest corruption that goes on in the state of New York are from people that can write multi-million-dollar checks, billion-dollar checks. It's not often that you see the everyday hardworking man out there who is getting busted for some type of scam. So the irrevocable standby letter of credit and the $50,000 or the $100,000 amount that's required, I don't see how genuinely that's supposed to weed out bad actors, because many of the bad actors can fill that fee no problem. What you're doing is you're, as I think it was Tom Devlin who said, you're eliminating jobs. You're actually reducing competition. And the other thing is the big point I want to make here is that this seems very one-sided toward making it that it's the consultants and that it's the brokers that are the problem. I have the utmost respect, and we deal with many of the ESCOs and the suppliers. Many of them are great. Some are better than others, but I respect them all. As colleagues, as strategic business partners. But when I've come into the situation, we literally have driven down the price that customers are paying directly with ESCOs. So you'd have a customer who would be with the same ESCO for 10 years just asleep at the wheel because of the direct relationship they have. And when we would come in as a broker or a consultant, and our roles is as a consultant, when we would come in, we would be able to create competition for them, competitively bid that out, show them where they've been overpaying just because they're trusting, what the ESCO is charging them is the best price they can be getting. And then despite the fee that we're getting, their net effective, they're paying less. And the way that this law is written and the way it's being enforced is that you want brokers and consultants to disclose, hey, we're making, 3 mils, 0.003 per kilowatt hour on electricity. And that's going to be viewed by a customer, by most who scrutinize the industry to begin with as, well, that means we're paying more going through a consultant than we are if we went directly to ABC supplier. And that's not the truth. And some of the largest ESCOs out there have, and I commend them for admitting in conversations when we've worked collaboratively with customers, has said that there is value to the consultants. There's value to the brokers because we do create a competitive marketplace that ultimately benefits the consumer. And this is going to create mass chaos confusion. It's going to create a lot of litigation probably. And you're going to be misleading inadvertently. I know that's not, the commission's objective, but inadvertently you're going to be misleading energy consumers in New York State to think that they're paying more by using an energy consultant or broker when in fact 99% of the time they're paying less. So I want to know how the commission intends to do that. And I would like to know if the commission is considering a way, personally, I would propose that the ESCOs have to include language if they're going to be disclosing the broker's fee to the effect of you're not necessarily paying more for the energy, or you wouldn't be paying less going directly through us to even make it a level playing field and for that consumer to even not feel like they're somehow overpaying, which is not the case. So I'd like to know how the commission is dealing with that. Have they considered that? And why are you not having the ESCOs disclose what their fees are? I've come across thousands of contracts over the nearly 20 years that I've been doing this industry where I was able to reverse engineer what margin was being charged by an ESCO, and it was outrageous. So it's like you're giving the optics of you're creating this fair market that you're enforcing it for the consumer to make sure that they're getting the best price they can get with all this transparency. But the one who actually is providing the price, you're not requiring them to give that same transparency. So I would like to know your thoughts about that, why there's a double standard, because it does feel like it's discriminatory. And just also, I would like an answer as to how you think it's in 2023, you're basically weighing the ethics and morals of somebody by whether they can come up with $50,000 or $100,000 and not by their track record of how they've actually provided services to their customers and clients.
Sure. So a bunch to unpack there. I mean, one thing I'll sort of start out with is, we take the law as we find it here, and these requirements were imposed by the legislature, specifically for these financial requirements, the compensation disclosure, and all of that. There's a couple discrete questions you had in there, and one was about articulating that the customer might not be paying more, even though there's this broker fee. And I think that very well may be the case. And to me, I think it's on the marketer, the broker or the consultant who's actually marketing to the customer, explaining the product that they're going to be enrolled in, to explain that their compensation and how it works, and the fact that this might nevertheless be a good deal. You know, the ESCO agreement already is required to have a number of things on it, and we're adding the compensation disclosure so that it's provided to the customer in probably one of the more reasonable locations. You know, the alternative would have been to require the brokers and consultants to directly provide this notification to customers regardless of whether or not they had a contractual relationship. And just going to the double standard thing, I guess, you know, maybe it has that appearance based off of, you know, your involvement in this proceeding and coming in here, but we have a very long track record in the retail access proceeding. And, you know, there are a lot of requirements that are very closely monitored with respect to ESCOs. And for a majority of the customers in New York, it's very limited, the products and services they can even offer. And those products are pretty routinely audited and confirmed that the customers are getting what they pay for. It is a much heavier touch on the ESCO side of things than what's the registration process that's being adopted here for brokers. I understand there might be certain requirements of the law that aren't required on ESCOs, and you identify as potentially unfair. But in the grand scheme of things, the ESCO requirements are much more thorough and prescriptive. And they get an actual eligibility regime as opposed to the registration that has been adopted for energy brokers and energy consultants.
Yeah, no, respectfully, I acknowledge that the ESCOs go through a vigorous vetting in order to be registered and approved to operate as an ESCO in New York State, and even in particular utilities. I get that. My point being, there's no transparency on that side. So it's not the appearance of a double standard, they're just the double standard. If the broker and the consultant has to disclose what they're making on a deal, and by the way, we disclose any customer we have or consumer we've had over the years, we disclose we're making a fee. And I don't remember the woman's name, I apologize, but how she was explaining it, it's a fraction of what the consumption is, and we tell them that it's a set fee, it's universal, there's no competing interest, and we charge the same fee regardless of what supplier wins the bid or who we recommend or what service we provide. But it's not the appearance of. I understand they go through a vigorous process to get approved to operate as an ESCO, but you're not requiring, or the commission is not requiring them to tell the customer, hey, on line one, we're paying the broker, 3 mils on this electricity deal, and then on the next line saying, by the way, we're making 5 mils on this electricity deal. You're giving the illusion to the customer that they're paying more by going for a consultant or by going through a broker. So I don't think it's on, I think there should be, and I would ask that you go back and look more into it, there should be some sort of requirement from the ESCO. I mean, I know we're certainly going to ask the ESCOs that we're doing, I guess they all have to do new contracts. We're going to ask for something like that, and I'm sure many of them will be amenable to it, because of the relationships. But there should be some requirement for them to let these customers know that just because they're going through a broker or consultant or they're paying this fee, doesn't mean if you were, hey, call me up directly right now, you're going to pay that much less. Because that's not the way it works. And I could give you hundreds, if not at least 1,000 different case studies that I've had of where I've shown that going through a consultant or going through a broker was significantly more cost effective than going directly with an ESCO. And that's why the indirect sales portion of the deregulated energy market in New York has grown significantly more than the direct sales over the past several years. There's one last question I do have that I wanted to bring up as well, is that I know there's a lot of motions that have been filed for stays and for rehearings and stuff, and we're all anxiously awaiting the outcome of that. But for contracts executed prior, I know this is brought up in some of those papers, but for the contracts that we've executed prior, or that any broker or consultant has executed prior to this law being enforced or put in place, for that not to be honored, I could understand someone saying, okay, if you don't meet these requirements or get this license, you can't do business going forward. But to not be able to service your clients.
Sir, if you could get to your point, there are 300 people online. You've had an extended set of statements, which I think we all appreciate your primary points, which are you believe that there should be more transparency in the charges by ESCOs. That's not the topic of today's discussion, but I assure you that Attorney Dwyer will bring it back since he is the lead attorney for ESCO regulation here. Number two, you've made a very good argument, or actually a series of arguments in your statements for the value of brokers and consultants, and I think everybody has heard and understands your points there. But again, there are some 300 people on the phone. In fairness to them, since we only have half an hour left, I'd like to move on. And Tom, if you don't mind actually moving on to the issue that you brought up, which is, I think, our number 5 on our list of 9 that we've only gotten through 1.5 of so far, which is what to do about pre-August 31 contracts. So we'll start that discussion, sir, and thank you for calling in, but we would like to hear from everybody else on the phone.
Of course. Thank you very much for your time.
And actually, I think the discussion on that will probably be pretty short. Again, that is subject to rehearing. Heard all kind of the comments on that. I understand them, that, they're pretty straightforward. What we staff were working with in our proposal, and I think the way that the commission looked at it in their order was just the language of the legislation that said, hey, if you cannot accept these monies if you're not registered. And so that's kind of the way that we've approached this, that going forward, if you're not registered, the entity should not be accepting those payments. But again, I understand that is the subject for the petition of at least one petition for rehearing, and the commission will speak to that again. In the room?
Michelle Pasecki from Harris Beach. Just one clarification point on that. I know you're talking about the commissions, but can you confirm that contracts that were entered into with an unregistered broker before 8/31 will be considered valid?
Yeah, that's actually a key point, and I'm gonna actually repeat the question because I think it's an important one. When we're talking about the underlying supply agreements, right? Those, if they were valid at the time they were entered into, with either, eligible ESCO, and pre-August 31st, it would be an unregistered broker, post, it would be a registered broker. But if they were valid when entered into, those contracts are not impacted by a subsequent loss of registration by the broker or consultant. The underlying supply agreement would remain unchanged. As we mentioned, there may be a change to the agreement between the ESCO and the broker, but the underlying supply agreement with the customer would not be impacted by that change in status for the broker. I know several people had that question, so I wanted to make that point clear. And one further distinction along those lines, what's really key here, we use the term enrollment a lot, but that's not always one point in time. That can sometimes be a two-step process where the customer signs up, which is sometimes thought of enrollment, or when the service is actually changed from the utility to the ESCO, which may be some point after the contract execution, given like switching dates with billing cycles and all of that. But what's really important here, and this is consistent for all of our proceedings, it is the contract execution. That's the date when we think of the date of enrollment. While the customer might not be technically fully enrolled until some future date, it's the date they executed the contract that's important here. So that's when we'll look to, okay, was there a valid, ESCO and broker at that point in time to determine if that enrollment was proper.
Can I ask a question, Tom? Amanda Trinity from Calgary. Yeah. So in that instance, who keeps the broker fee?
Meaning?
So like if there's something that's not worked out, but the broker fee is built into the supply agreement, does the ESCO just keep that?
So, that's a question we got from a couple of folks, and the order doesn't speak to that specific scenario. In thinking through, so I think the example that you're putting forth is we have a contract with a broker, facilitated by a broker, that's getting commissions and stuff. And then the broker decides, I'm not going to do business anymore and I'm stepping away. The ESCO stops paying them, but then arguably the supply rate has gone down because there's no longer this fee associated with it. The question being, is the ESCO required to re-rate the customer? And unless there's something addressed in the terms of the agreement are ultimately, I think, what's controlling here. The commission didn't impose any specific requirement that the customer get re-rated at that point. But that was an interesting point that was raised, and it's something that we're considering here at staff, how to potentially address that. All right, so in this discussion, we're not really following our list as closely, but we're checking off kind of a lot of the questions that we got in advance. I want to go back to a couple folks on the phone. I know Joey Lee, you've been waiting for quite some time. Let's go ahead.
Tom, can you hear me?
Yep.
Okay, great. Thank you very much. I have two questions. One is actually a confirmation.
And Joey Lee, who are you representing?
Joey Lee Miranda, sorry, on behalf of the Retail Energy Supply Association. With respect to compensation disclosure, you made the comment that in most cases, the ESCO will include it in their customer disclosure statement. I want to confirm the order says that is only if the ESCO is actually paying the broker, that the compensation. So for instance, if a broker, as an example was given, has a retainer with a customer and gets paid directly by the customer, the ESCO is not going to know that. And the order says, I'm correct, that I'm asking you to confirm that I'm correct, that in that case, the ESCO is not required to disclose. Is that correct?
Yeah, that is correct. And I'm even going back to the language of the statute, which I'm trying to pull it up here. There was one specific subsection dealing with that. Here we are, and that was 4B. Starts out with if an energy service company collects broker compensation on behalf of the broker or consultant, that shall be added to the customer disclosure label and reflect the amounts and method and so forth. So that is, that's only in cases if the ESCO is collecting it on their behalf. That's, the sort of a clarification to the general rule that says brokers and consultants are required to disclose the form and amount of compensation.
Great. And then the other question really goes to the question Amanda asked earlier, which is what's going to happen when you haven't gotten through everything? Because I know there were questions we asked that perhaps you have decided not to answer because you feel like they've answered, but there are some that I don't think we have, like even the subject matter has been touched on yet. And I'm just trying to make sure there's going to be an opportunity for people to get feedback on some of these issues.
Yep, I mean, staff will continue to answer the questions as we have been, just as they come in directly to folks. And like I said, after this meeting, staff will huddle and kind of plan on next steps, whether it be another conference or whether it be some written guidance. That, more to come on that.
Okay, thank you.
Okay, I do still see some hands raised, but I wanted to try to get to some of the other issues here. I think maybe we'll skip over some of the application questions. I think those are easy enough to answer directly to folks. Let's see, we addressed those ones. Well, here's kind of a discrete issue, and hopefully I can talk to it and address it all together. But we got several questions on data security agreements and the process to get data from the utility. One thing I do want to know is the order from June addressing energy brokers and energy consultants didn't change anything in this regard. The requirements for the commission's kind of basic cybersecurity protections can be found in a case 18-E-0376 And there's a couple orders in that case that basically lay out anyone who, any entity seeking to get customer data from the utility, lays out the process by which they do that. And this is all with the customer's consent, assuming that's all been taken care of, really, how do they physically accomplish that? And it focuses on protection of the data. So making sure that entities have basic protections in-house if they're going to be housing customer data, that they can prevent it from improper disclosure. And protecting systems if they're directly interfacing with the utility to receive customer data, that they're not, putting the utility system at risk, which has even broader concerns. So what the commission has required is that any entity seeking to get customer data from a utility must execute a data security agreement with that utility. And again, this applies to anyone, not just ESCOs or brokers or what have you. Those requirements, again, the DSA itself, there's a couple different forms of DSA that the commission has sort of blessed. One is specific to CCA, and then one is kind of the more general one. I think it's the more general one, obviously, that would apply here, that has both kind of terms and conditions for, the rights and responsibilities of the parties to the agreement, and also has what's called a self-attestation, which is sort of an addendum listing out some of the key controls that the commission expects entities getting customer data to have. And that is a self-attestation where the entity will attest that, yes, we have all of this. Again, those requirements are in place today. The utility generally should not be exchanging data with ESCO brokers or consultants without having the DSA in place. So I think I'll pause on that one. That was all I had. To see if there are any questions specifically on the receipt of data and data security agreements. And I know we have a bunch of hands up from earlier. I don't know if they're specific to this, but let's go through, let's go down to some of our questions here. Edmund, go ahead.
Hi, this is Edmund O'Dean from First Service Energy. Just going back to the disclosure of compensation again, is there any concern that the current approach of fee disclosure will disclose any sensitive competitive information? Has the PSD thought about looking at how other territories or other commissions have a fee disclosure and amend their approach? I think Illinois has a very good approach. So does DC, so does Texas. These are all precedences that hopefully the commission has looked at, but has the commission looked at, is the commission concerned at all about the industry?
Mr. Hain, let me pick up your question. This is Richard again. And thank you. You already spoke once, but I think this is something worthwhile to bring up. Did you provide any examples from the other states that you were mentioning now during the comment period where the staff and the commission requested comment from people in the industry so that it could inform analysis here? If the answer is no, that's okay, but please send all that in. And at this point, I think I'd like to have Tom move on to the next question since we already got a chance to speak. Thank you.
All right, I'm just going through our list here. I think, again, a bunch of these are related to specific registration form questions, which I think are very easily answered in writing. Inquiries. All right, I don't want to keep as I go through the list here. So let's jump on to another one on the phone. Assuming, again, trying to keep us on topic here, but let's go to Matthew.
Hi, I'm sorry. Good afternoon, everyone. Can you hear me?
Yes, we can.
Okay, great. It's Matthew. I sold to Greenland Energy. Hope everyone is doing well. I want to touch base. I know it was really quick on the third-party registrations. I just think there's a little bit more to discuss there. There are some consultants slash brokers that have a ton of 1099 business, which actually is their whole business. And I think what a lot of people were assuming was that if they weren't able to or did not want to obtain this registration in New York, that they would use a third-party broker slash consultant and work underneath their licensing. So if the commission is asking for anyone, whether it be 1099 or employee or agent, to also register, that would actually put those corporations out of business, because that is 100% of how they run. So what I'm trying to figure out also is for myself is if I'm having agents underneath my license, if they also have to become licensed, there obviously is no point for them to do business with me. They would just do business for themselves. So I just want to know if there was any kind of, more clear definition on how they're going to, work those contractors and agents.
Yeah, so you mentioned contractors, agents, and employees. And just to be clear, the commission did specifically exempt employees of a registered entity from also having to register themselves. It did not extend the same exemption to independent third parties, contractors and agents as you described. Again, though, I will note that is subject to at least one request for rehearing right now. So that's sort of, I guess, potentially an open issue. As of right now, it is just those employees that don't have to register, those direct employees. But the commission will be speaking to that point again in the future.
Okay. Yeah, that's a small side of my business, but I know the other companies that do this specifically are getting flooded with brokers who can't comply to this $50,000 or $100,000 ruling, and they are assuming that, okay, well, if I can't get this license, I can work through someone else's license as a 1099. And if that's not the case, and they're going to require everybody in the state to do business as either a broker or consultant, those businesses pretty much go belly up, because that's their whole platform. That's what they're selling is, come use our relationships with the suppliers, come use our web-based platform to do all the procurement. So I just wanted to because I also have 1099 sub-agents as well. So I just wanted to be able to know what I need to be able to inform them on if we're going to be doing business in the near future.
Yeah, understood.
Okay, thank you very much.
So we are, checking through a lot of these questions that we got in advance. Let's just let me get back to WebEx here. Still a lot of hands on the phone. Let's go to Nate.
Interax. Wanted to ask about specifically dealing with customer data. It's pretty clear on data that's coming from the utility, but how broad of a definition of customer data would you consider needs to be protected? Contracts, usage, bill history, what level of protection needs to be provided from an IT or data security perspective?
Right, so customer usage information, person identifiable information, things like that is considered protected. And, if held by like a broker or, consultant, should be protected from improper disclosure.
So customer legal names, tax IDs, addresses, etc., all of that would be in scope in terms of data requiring protections defined under the DSA and self-attestation.
That's right.
Okay, thank you.
All right, Jennifer, how about let's go to you.
Hello, can you hear me?
Yep, we can hear you.
Oh, okay. My name is Jennifer McCabe. I'm with Bevan, Mosca, and Jadida. And if it's okay, I actually have two questions that hopefully are quick ones. One is there's a question on the registration form that says, provide the contact information for any affiliates conducting energy-related business, including subsidiaries and parent corporations with New York State or elsewhere. I haven't been able to find a definition of what you mean by energy-related business. Could you please provide some clarity on that?
Sure, I guess it would be businesses that ultimately tie back to an end-use customer's use of gas or electricity. I think, you know, probably generally we're likely thinking of ESCOs and DER providers. I think those are two pretty, well, DER providers, a pretty broad category that that covers a lot of energy services, everything from like energy efficiency to solar, demand response, and what have you. I think it's those types of businesses that that question is getting at.
Okay, thank you very much. And then my other question is regarding the fee splitting and compensation disclosure. If an ESCO is paying a marketing vendor who has to register as an energy consultant, and they pay a fee to that marketing vendor per customer, but then that vendor pays a portion of the fee to the office, who then pays a portion of that fee to an agent who works for that marketing vendor. Do all of these layers of the fee splitting need to be disclosed by the ESCO? Because in a lot of situations, the ESCO is not even aware of all that downward fee splitting.
Yeah, absolutely. And that's what we touched on briefly earlier, is there's that general requirement to disclose on the ESCO agreement the fees or the compensation that's collected, you know, under that agreement. But there may be these additional fee splitting scenarios that are really just between the broker and X party. Those should be disclosed directly by the broker or consultant.
Okay, so to be clear, you're saying the ESCO would not need to disclose that?
Right, that's what I was about to say. As you mentioned, ESCO in most cases may not even be aware of that type of fee splitting arrangement.
Okay, thank you very much.
Okay, let's see. We have a John on the line with their hand raised.
Hello?
Yes.
Can you hear me?
Loud and clear.
Okay. So obviously the call gets off rails and there's been a lot of questions that won't be
And
answered.
John, what's your full name and who do you represent?
My name is John Tyler with Efficiently Green in New York. I think at this point of the call, since we're 9 minutes to ending it, my biggest issue or question would be, if a broker and consultant, at what point will the broker consultant be considered registered? Because if let's say we submit today, it would be before the 31st deadline, but the commission would have to review that first and then submit approvals. So I think a lot of us are in a position where we're going to be in a delayed gap or period of basically being out of business. I want to know what the commission expects for turnaround and how we should handle this.
Yeah, absolutely. So on the timing, the order did kind of lay out sort of, I guess, like a grace period for pending registrations. We're going to get a lot of registrations come the end of the month, and staff's not going to review them all in a couple days. So the commission established it was till like in December, so like 3 or 4 months for staff to do this initial review, which will be kind of the lion's share of this work right up front. That does not mean that entities are out of business during that review process, as the commission had stated. Brokers and ESCOs can continue operating and doing business with one another, basically until there's something official from staff. And the way I think to best handle those kind of responsibilities is as long as you get your registration in by the 31st, you're kind of entitled to that additional grace period. But if you don't file by the 31st, you're not registered at all and you made the attempt to be registered, then I think you would be considered not registered then. Yeah, follow up in the room.
And my thought just escaped me. Oh, here, back on it. Amanda Trinzy from Couchbay. Are you going to publish, like you do for the ESCOs, like a list of all registered brokers and consultants?
Yep, we will maintain a list on our website. Obviously, that'll be populated as we actually review applications and approve them and so forth. For the time being, I think, I've gotten the question, well, in the meantime, how do I, ESCO, ensure that my broker is registered or at least going through the process? And the feedback we've given is to, the ESCO should check the docket, come August 31st, just to make sure that the broker or brokers they're doing business with did actually file their registration. With that check or that confirmation, they can, continue to operate, do business with that ESCO while the registrations are being reviewed. Follow up in the room?
Yes, hi, Angela Shore from NRG. So I have a question on that. So you're saying ESCOs should check, we'll say 9/1 to be safe, to see if the brokers all submitted, the brokers that we're dealing with all submitted applications. And then what? Like, how often will the lists be maintained? How often will they be updated? What responsibility do we have for continuing that review process? Can we rely on those lists? Will they be real time? These are the types of questions we have internally as we try to set up our processes.
So I think, well, first of all, the list will be updated pretty regularly, basically as things change. We need to create the list first, and we're going to do that as we get eligible entities, or I should say registered entities, approved and in the system. Again, I think ESCOs can afford themselves of that sort of that grace period. I would say yes, check, right around the filing to make sure that your broker or brokers got in the door. But then, I think it's only reasonable to allow the ESCOs to sort of rely on that until the end of that period, which it's currently December 31st, or maybe it's earlier, December 1st. That's probably the time to check again to make sure, okay, that's when staff will have that list official to make sure that their broker filed and got fully registered and everything.
What if the broker's not registered? Like, I'm just gonna take it one step further. Like, what happens then?
So if they don't register, then the ESCO can no longer use that broker to sign up customers and so forth. All right, we are almost at time. It probably makes sense just to kind of talk about sort of next steps. I know we checked off a lot of questions, but certainly not all of them. And I know there's a couple issues that we probably didn't even really get to in earnest. Staff is going to take back the questions we received here today that we didn't have answers for, and go back and look at the ones that the pre-filed ones that we didn't get to. And we'll decide kind of the best way to get responses out to folks. We may end up in the not too distant future creating a kind of an FAQ document as we discussed. And we'll also look for availability and options to potentially host another webinar. There are a lot of logistics with trying to make sure we get folks in person, get the remote rooms set up. So it takes a little bit of time to set those up. So bear with us while we work through that. Can we go on? I think we have just some slides, maybe just contact information. Yeah. So just contact information for folks for questions. I know Adam is identified on the website. Kelly's also been fielding a lot of individual questions from folks. Let me pause and just see, you know, we have a couple minutes here, like process wise. Are there any questions or anything to along those lines? So I know there's a lot of hands that were raised from before. I don't expect that they're all process questions. Oh, I just got a thing. Gloria, you might want to raise your hand if you have a question. Well, let's just see, like Joe Sutton, go ahead. Nope. Okay. Tom Puckner, did you have a question on process as we wrap up?
Thank you, Tom. I'm going to yield the mic to Stacy Frontala that was waiting patiently since before I put my hand up, if that's okay with you.
Sure, I don't see her on, I don't have her hand up here though. Is she in the room with you?
I believe she was on. Maybe the gremlins and the machines got in the way. I'll go ahead anyway. These are not process questions, but I do have a couple. There was a brief discussion about the bonds and enforcement. I believe that was by the gentleman that had submitted the letter, whose name I now forgot. But I wanted to follow up briefly on that and see if you had anything that you could add to it. In the event of an enforcement under the UBP, the new section 11, I guess is what it is. I don't see a procedure in there specifically to, I'm talking about like mechanically, to draw on the letter of credit. There's a reference to $5,000 or, you know, a multiplier times the amount that was the rebate or charged. I think it was the language, but I don't see anything connecting to the letter of credit. And I just wondered if you could speak to that.
Yeah, I mean, that would just be, again, part of the typical enforcement process that, you know, included in the new UBP section 11 and UBP DERS section 4. There's an enforcement, lays out the enforcement process, which again matches the enforcement provisions of section 2. And as part of that, you know, the commission has pretty broad authority to impose consequences. I think there's a non-exhaustive list that lays out some of the more typical ones, but I think as part of its normal enforcement and its ability to impose consequences that it seems reasonable, it would, you know, it could direct drawing down on the letter of credit. And I want to actually say something because I didn't get to finish my thought earlier, but I want to note that drawing on the letter of credit is not going to be the default option. Ideally, I mean, if you know, financial harm was, you know, was incurred by customers, the direction in most cases, as you've seen, like might be like an ESCO to re-rate that customer, to provide a refund to that customer, you know, something along those lines. That would be, I think, probably the first kind of consequence imposed in these instances as well. The letter of credit is really for instances when the party's financially insolvent or otherwise unable to provide, to redress that harm to customers. You know, then we'll have potentially some money to draw on so that we can get that back to customers. But that isn't going to be kind of, at least in my mind, the first thing that the commission will jump to.
Exactly. So that's speaking of the jumping, it's like just mechanically, right? So typically there will first be an order directing re-rates, or it might come in a NOF, and then if the re-rates don't happen, there's a further order or further orders. I'm just trying to understand that process that the gentleman was talking about.
Sure, and I mean, obviously, like these are very fact-specific kind of endeavors and orders. You know, it may be determined after the order to show cause, based on responses to that order, that this entity is insolvent, and they do say, yeah, okay, you know, we're going to draw on the letter of credit. It may be first you pay customers, you know, a refund, and if that's, you have insufficient funds, then, we draw on the letter of credit, or it could be a separate order. I think, it'll depend on the facts of the enforcement action itself. But in any event, it'll all be done kind of open and publicly in commission orders.
Okay.
Right, just a little more detail, and if you look at the order, page 36, 37, it talks about the notification before drawing upon any letter of credit. The commission would first issue an order describing the violation, similar to all our enforcement, so we don't just go to the letter of credit. There's a process, there's a procedure, there's investigations, our staff, our attorneys work on that, so, but again, page 37 of the order has a little bit more detail here.
All right, and
Yeah, I'm just not seeing that in the UBP that was actually adopted. Maybe that's coming in the October UBP, but I just looking for your thoughts there. It sounds like you still anticipate that, even though it's not in the UBP because it is in the order.
Well, as I mentioned, that's in the UBP. It's in that part of that non-exhausted list. I'd say, the drawing on the letter of credit is included in that, or other consequences the commission may impose. There's any number of things that the commission can and has imposed in response to, as part of these enforcement proceedings that aren't included in that specific list, which is, again, it's specifically mentioned as non-exhaustive.
Gotcha. Thanks, Tom. Follow up on the question about underlying customer contracts for brokers, either pre-August 31st or post-August 31st. Just a further refining on that you mentioned. So you have customer contracts that might have been executed before or after, and they're valid at the time, at least in terms of the broker or the consultant registration, or the not needing it at that point. In the event that there's later lapse or they don't register, but the contracts with the customer that are held by the ESCO at that time were valid, can those be renewed also? The question is about renewals of contracts that were valid at the time. I assume that that's the case, but I wanted to hear it out loud.
I think I see what you're saying. I mean, the answer is yes. The only caveat there is, upon renewal, there may be a requirement to update the customer's agreement as required by the order regarding compensation disclosures or what have you. But generally speaking, there isn't a problem with renewing that agreement. Ultimately, the underlying supply agreement, as long as it was valid at the time it was entered into, should be unimpacted by future changes in a broker or consultant's registration status.
That makes sense. Thank you.
All right, and I know we could probably keep going here for another 2 hours, but we are well over time here, and want to be respectful to other folks' time as well. Like I said, we did not get to everything today. I thought it was optimistic to think we would, but there will be more to come on this from staff, and also as I mentioned earlier, I do expect a procedural ruling from the secretary on some of the extension requests, and ultimately on some of these issues. Again, we will very likely hear from the commission again in response to the petitions for rehearing. With that, again, I do want to thank everyone for the time today. I hope folks found this helpful. Staff's tried to make itself available and provide guidance where we can, and we will continue to do so as we work through these new processes. But again, thank you everyone for taking the time today.